Okay, مساء الخير وأهلا وسهلا بالجميع. Good evening, everyone, and thank you so much for being here with us today. So as you know, in Beit Sahur, USA, we like to host webinars about important topics every once in a while to educate people in our community. And tonight's webinar really touches every family, even though it's not always easy or fun to talk about it, especially in our culture. So tonight's webinar, Trust and Wills, is all about planning ahead to protect ourselves and our loved ones. It's not just about having a legal document, it's more about peace of mind. So whether you're just starting or you already have one in place, we hope tonight's webinar benefits you one way or another. So just before we start, just housekeeping items, please stay muted, and then the whole webinar should not last more than an hour. The presentation should be about 30 minutes, and then we'll open it for Q&A. Okay, and now it's my pleasure to introduce our tonight's speaker, Mr. Amir AbuAita. Mr. Amir AbuAita is an attorney based in Michigan. He practices elder law, Medicaid planning, VA planning, probate, state planning, business transactions, and assisted living law. He's a member of the Guinness County Bar Association, as well as elder law and probate state planning sections of the State Bar of Michigan. In addition, he serves as a member of the Guinness County Commission on Aging, Adult Foster Care Providers, and board member of Elder Abuse Alliance, formerly known as the Elder Abuse Task Force. He's been selected to the Michigan Super Lawyers 2021-26 Rising Stars list. Each year, no more than 2.5% of the lawyers in the state are selected by the research team at Super Lawyers to receive this honor. He has also been selected for the 2022-26 Best Lawyers Ones to Watch in America for his high caliber work in elder law and trust and states. So without any further ado, I would like to welcome Mr. Amir, and hopefully you enjoy this webinar. All right, تفضل Mr.
Hi, everyone. It's good to see everybody's beautiful face here. I'm going to put on my presentation so you guys can see. Can you guys all see my presentation over here? It
Yeah.
says estate planning basics.
Yeah,
Thumbs up.
we can.
Oh, perfect. So we're going to talk today about estate planning. By everyone's face in the camera, can you guys raise your hand if you're never going to die?
Can you please mute everybody, Adil? Some people are in the background.
So what I was trying to get at is that everyone's going to die one day. And I don't mean to say it with a smile on my face, but it's true. Today, we're going to be talking about some generalized estate planning concepts and strategies. For estate planning, there's no one size fits all. So everyone's going to have a different need. And that's what I'm going to be talking about tonight, to make sure that everybody has options to be able to understand what estate planning actually is and what they would want or need when they're talking about this with their family. Now, a couple of housekeeping measures. I'm not making this presentation as giving legal advice. So I'm not establishing an attorney-client relationship with any of you by making this presentation. So please don't take it as such. And also, I know there's a lot of the viewers today are from different states. So I know some are from Texas and Missouri and California, or wherever it may be. I'm only a practicing attorney, a licensed attorney in the state of Michigan. So please don't take that as legal advice in your general state. If you want to seek legal advice, I would recommend getting legal advice from your state itself. Without further ado, we're going to talk about some frequently asked questions. That is what FAQ means, by the way. So some of the questions what we're going to ask that are most asked is, what is estate planning? Okay. Who should have an estate plan? What legal documents make up a basic estate plan? What is estate administration and probate? What types of taxes are involved with estate planning? And we'll talk about dying, make death approach faster. Okay. I'm going to answer the last one for you guys right away. No, talking about death is not going to make this happen faster. Okay. What is estate planning? Okay. Estate planning is just an estate, it allows you to control your assets upon your passing. Or if you're not, or you're still alive and you're in really, really bad shape, whether you have a medical condition or a health issue, or just generally having a bad day. Okay. Um, some of the most common goals in estate planning is making sure that assets are going to be managed properly if you become sick or you die, making sure that the assets, your money and your property get passed to the correct people at the time of your death, making sure that we maximize tax avoidance, unnecessary tax avoidance. Although I'm not a CPA, I would refer that to one of my colleagues, Fadi Rishmawi. I'm sure a lot of you guys know him. He's pretty brilliant when it comes to um, talk about tax and information about taxes. Avoiding ambiguities, avoiding unsurety of what your family's going to do, what happens if you do pass away or you get sick, and really just understanding what costs are associated with an estate plan. So we're going to talk about all those things today. Okay. Is there anyone who should not have an estate plan? And the answer is no. Everybody should have some sort of estate plan. Whether it's a basic estate plan or whether it's an advanced estate plan, it's recommended that everybody has some sort of an estate plan. At the very least, everybody should have what's called a power of attorney, and we're going to get to that in just a second, probably farther on in this conversation. Okay. Plenty of people say, hey, I don't have enough money to have an estate plan. I don't have $1 million. I don't have $100,000. I don't have $10 million. It doesn't matter how much money you have. When we talk about estate planning, it just matters about how important is it for you to make sure that your family is protected and the right assets go to the right people. So one big thing we talked about, I spoke about this topic a few months ago at St. George here in Flint. And one thing that really made a lot of sense to me, or it made a lot of sense to the people that were listening to my presentation is, do we know, do our families know, do our husbands, do our wives, do our kids know how to handle our affairs if something happened to us today? And a lot of the response I was getting to that question is no. A lot of our families have businesses, we're business owners. Do our wives, do our husbands, do our kids understand how to handle those transactions in those businesses if something happened? And for the most part, the answer was no. There was a few that are training their children into their specialty um, occupations, but there's not enough in at the presentation I was making to make it a feasible concept. Okay. What does an estate plan include? Okay, so we're talking about just general um, estate planning topics, which include, or tools, sorry, that include last will and testaments, um, trust, powers of attorney, which I mentioned earlier, advanced healthcare directive, which is called a living will, and beneficiary designation forms. When we start talking about beneficiary designation forms, I'm going to hand that over to Nahal because she works at a bank, apparently, right? Yeah. So she's going to be able to help you with that when we get to that topic. Okay. What is a last will and testament? Okay. So otherwise known as a will. Okay. A will is one of the most important documents you can have because we want to make sure it allows us to write down who we want to receive your assets when you pass away. Now, it also names somebody called a personal representative or an executor, those terms are interchangeable, to be in charge of your money when you pass away to make sure it gets to the right person. Now, what people don't understand about wills, okay, for the most part, the big misunderstanding about wills is the only time that you should have just a will is if you're prepared to go to probate court. Okay. What that means is if you pass away, you have you have an asset in your name. Okay. And it needs to go to your spouse or to your children. The probate court is the only entity that will read a will and make you follow directions, make your family follow the directions of a will. Most of the time, people don't want to go to probate court. It's costly, it's expensive, and we'll go through that in just a second, okay? What do you think a will is right for you? And let me give you some advantages and some disadvantages. Okay. And by the way, this presentation I can send to anybody if you would like. And what I would probably do is if there's an email chain that I can send this to, that you guys can refer back to this after this presentation. So is a will right for you? The advantages of a will is avoiding property passing to people you don't wish to receive it. Okay. I don't want my son to receive something. I'm going to write it in my will that says, I don't want my son to receive my money. Okay. It avoids disputes over intended beneficiaries. So if you have 4 children, okay, and the kids the kids think that they're going to receive everything, and let's say you want one to have more than the others, okay, it avoids disputes over intended beneficiaries. So it makes it clear and concise in a document form to determine who is going to get what and how much they're going to receive. Okay. Tax advantages, we're going to skip over that just tonight because we don't have enough time to talk about that. And it clarifies the rights and the duties of the personal representative of the executor, giving them the rules and giving them the guidelines that they have to follow in distributing these assets to your beneficiaries. Okay. Now, the disadvantages of just doing a will is probate fees. Okay. I particularly don't like going to probate court unless I absolutely have to. So in my practice, most of my clients, if not all of them, typically avoid probate court when a loved one passes away. How do we do that? I'm going to tell you how in a second. But probate courts fees can be very expensive, very timely. They kind of take control of a lot of aspects of your administration. There's not much privacy. So if you weren't very open with your relatives or family or whomever it may be of what you owned, what your net worth was, well, once you go to probate court, there's no secrets. Everybody, it's going to be public record of whatever your net worth was worth when you pass away. So that is another reason why we have a disadvantage. And then just the timing of probate court. It's just a major disadvantage because it takes a long time. So a big topic that we're going to talk about today is called a trust. Okay. A trust is different from a will because what a trust is, it's basically an arrangement that allows an entity to control your assets when you pass away instead of the court. Okay. So if you pass away when you have a will, with just a will, you have to go to the court or the mahkamah to make sure that the assets get to your family. If you have a trust, okay, you can distribute your assets to your family without going to probate court. Okay, that is the major difference between the two. Okay, we're going to talk about trust just right first, the next few slides. What roles are involved with the trust? And like I mentioned before, a trust is an entity. Okay, there's 3 players in this entity. There's a grantor, is the person who establishes the trust. Okay. They decide what property goes to who. Okay. And they determine what beneficiaries are going to receive it and when they're going to receive it. Okay. So for all you that don't know, I have an 8-year-old son named Zane. Okay. And I don't think giving an 8-year-old a distribution or an inheritance is a very smart idea for 8-year-olds. Okay. In my trust, I wouldn't want him to receive these assets right away. I have a house. Okay. I don't think I would want him to receive the proceeds from a house at 8 years old. So I can write in my trust document, I don't want him to receive this money until he turns, let's say, 25 years old. Okay? Why would I do that? A, I want to have control of, you know, beyond the grave. And B, I think, let's say I think that at age 25, he's going to be ready to be able to manage his own money. Okay? So that is what the creator or the grantor of the trust is able to do. Now, the trustee of the trust is the person who actually implements the plan. So if I pass away, and let's say I placed my brother as the trustee, he will be in charge of making sure that the trust assets, anything that we place in the trust, which is, let's say, my house and my bank account and my car, whatever it may be, goes to my 8-year-old son at the age of 25. That is the person that is going to be in charge of the assets until final distribution. Okay. Now, that's probably the most important person that you're going to have to find out, and you're going to have to figure out who that would be. It would be someone that you can really trust, pun intended. Okay. And that person will also make investment decisions and things like that, decisions like that. Beneficiaries is the third group of individuals that are going to be part of this topic. Beneficiaries are the people or entities who will receive the benefits, who will receive the assets from the trust. Okay. And they will receive the income and principal and whatever it may be. You can specify, hey, I want this person to receive my house. I want this person to receive my car. I want this person to receive my bank account. The people receiving the assets are called beneficiaries. Okay. So here is the advantages and the disadvantages of having a trust. And because that's a very popular question that I get asked a lot, is the advantages of having a trust. The first one is beneficiaries can gain access to assets more easily than if it's transferred to the will. So like I mentioned before, if we have a will or just a will, we're going to have to go to probate court in order to receive those assets, for the beneficiaries to receive the assets. If we have a trust, we don't have to go to probate court in order for the beneficiaries to receive the assets. Okay, so that's the first advantage. The second advantage is control when and how a distribution can be made. Okay, I can say, well, I don't want my son Zane to receive any money unless he becomes a lawyer. Okay, I can write that in a trust. Now that sounds like kind of a ridiculous provision. I wouldn't want to do that, because if he doesn't become a lawyer, then he gets nothing. That doesn't make sense. But I can control that. I can make that provision. Obviously, probably not the best decision to make, but that is the extent of the control that I can have while making these estate planning documents. It protects assets from creditors, divorces, and spendthrifts. Okay, this is the most important thing about trust planning. Okay, so I'm going to keep picking on my own son. Okay, let's say he's a beneficiary of the trust, and let's say he gets sued. Okay, well, what this trust can protect, any assets that are held in trust for the benefit of him, can be protected from any creditors or any lawsuits, if the trust is created properly, of course, any lawsuits that are directed towards Zane. Okay. Now, this again is the most important part about a trust, is because what you're really doing here when you're creating this trust is you're basically engaging in a life insurance, no, I'm sorry, not a life insurance policy, an insurance policy to protect your beneficiaries from life, whether they get sued or divorced or they become disabled. Okay, life happens. These things happen. Okay, so and then obviously one of the most important things is it avoids probate. Okay, the disadvantages of a trust are the fees to set up a trust. Now, uh, the fees to create a trust are much more in in respect to the will or just doing a will. Okay, ongoing trust administration expenses, and if a if you do a trust, if you create a trust and it's not funded properly, okay, we can find ourselves going into probate court if we don't follow the directions of the trust, which doesn't happen very often. And but if it does, it just kind of defeats the purpose of even having a trust. We would need to go to probate court. So there are different types of trust. The most popular one that we create in our office is our revocable living trust. That's the everyday estate planning trust. Okay, there's multiple types. There's marital revocable living trust. There's joint revocable living trust, and there's single revocable living trust. Okay, there's other types of trust called irrevocable trust or irrevocable trust, however you want to pronounce it. Special needs trust, um, for people who have kids who are special needs or beneficiaries who are special needs that are currently receiving governmental benefits, that we don't want to have any inheritance disrupt those governmental benefits. Testamentary trust, charitable trust, and asset protection trust. Those are not as popular as the first three, but still types of trust that we create every single day. All right. So I'm going to ask Nahal to unmute herself just for a little bit because I want her to help me with these next topics. Nahal, do you want to unmute for a second?
Yeah, sure.
All
Thank you,
right.
Amir.
So Nahal, I'm going to just kind of guide you into this. And so there are ways without a will or without a trust that you can make sure that your family receives the assets in certain types of assets without going to probate court or without having estate planning documents. Okay, so those are called beneficiary designated assets. So Nahal, can you explain that for me?
Yeah, so beneficiary, it's called payable on death, BOD, and you can add it into the account. So if something happened, that person died, the beneficiary take over. The difference between the beneficiary and the trust, when you have beneficiaries, like I have two, three beneficiaries, is going to be divided by three of them. So if you have three people, it will be divided, so you can choose percentage. It go to all the beneficiaries divided by the number of the beneficiaries. When you have a trust, in the trust, you can choose how many percentage, because like as Amir mentioned, there is a trustee and there are beneficiaries, we call them successory trustee. This is when people passed away, they take over. You can choose the percentage for each person, how much the percentage they will take over. So you have a control, like, sometimes people, they want to give more percentage to son than daughters. Other is opposite, like, some people, like, they want to give to other family as well, so they give their kids the most percentage and other family different percentage. So that's the difference between beneficiary and when you have a trust. Um, if you have a will and you don't have beneficiary or a trust, uh, if you don't have nobody in your account, you can't do anything. You have to go to the court to create a state and come and have access to the money. So if there are no names on the account, you can't access to the money. And it's a very long process to go and take the will and get everything. And it take a long time for that.
Yes. Thank you so much.
Mhm.
I really appreciate it. Thank you for your professional aspect of this of beneficiary designations. Now, of course, along with what Nahal was just saying, if you have a trust, okay, the beneficiary of the trust, or I'm sorry, the beneficiary of your bank accounts and all your other accounts will be your trust. It will not be your kids or your spouse or whatever it may be. It will be your trust Because in your trust document, you can spell out, I want my wife to receive 100%, or I want my husband to receive 100%, or I want my kids, if I have 4 kids, that they get 25, 25, 25, 25%. Okay? This is how that bank account gets into the trust by beneficiary designation. Now, I'm going to take it one step further and talk about not having a will and not having a trust. Okay? Could we still do estate planning without a will and without a trust? Yes, absolutely. Absolutely. You can place beneficiaries on all of your bank accounts and all of your assets. Okay? In Michigan, we have a way to put a beneficiary on real estate that is called a Lady Bird deed or enhanced life estate deed. Okay? They're also legal in Texas and Florida and like 2 other states. But in Michigan, we can put beneficiaries on real estate, which is really, really beneficial for us Michiganders, because we don't have to do a trust if, let's say, we have 1 child. Okay? All right? But the best practice is always to do some sort of estate planning. But if you absolutely are totally against it and you are totally anti estate plan, at the very least, make sure that your assets have beneficiaries on it. Because if you don't, like Nahal was just saying, we're going to have to go to probate court, to the mahkamah, and it's going to be a nightmare. I don't like doing it. It's, it's a pain in everyone's butt. Right, Nahal? Yes? Yeah. Perfect.
Yeah, for sure.
Perfect. So the advantages of just putting beneficiaries without estate planning is you can have multiple people, entities, or trusts as beneficiaries. Okay? The issue with that is if you have 2 kids and you want your 2 kids to be the beneficiary, if one of them die or if one of them something happens, let's say, then there's no clear writing in the beneficiary designation as if the other kid gets everything. We don't know. It depends on what kind of financial institution you're working with. Okay? It is the most time and cost efficient way to estate plan is placing beneficiaries. Okay? But if you only put 1 beneficiary and that person dies, where does it go? Where does your money go? Okay? We're going to the court. We're trying to avoid court at all costs. Okay? And I have a is it a hand raise? Can we wait till the end?
Yeah, keep going.
Okay, perfect. All right. Can probate court be avoided? Yes, probate can be avoided with proper advanced planning. Okay? An estate plan can be designated to limit assets that can pass through probate or to avoid probate altogether. Okay? Probate court versus non-probate court property differences. Okay? So, we're going to go to court if you have an asset in your name, just in your name, that has no name beneficiary and no joint ownership. Okay? Or if we just have a will. So again, if you have an asset just in your name with no beneficiary, or you have a will or you don't have a will, we're gonna go to probate court. Period. Okay? And I have a diagram in my next slide, by the way, that'll make it a little more clear. Non-probate assets that we don't have to go to probate court for. Jointly owned property. So if you or your wife or you or your husband own a bank account jointly, and if one of you guys die, then the other one receives it. Or if you own a joint bank account with your son or your daughter or whomever it may be, if you pass away, they get it. That avoids probate court as well. Not my favorite type of planning. I like beneficiary designations better, but that is a type of planning. Non-probate assets also include beneficiary designated property, which include life insurance, IRAs, 401ks, bank accounts. Okay, if there's beneficiaries, we can avoid probate. Or in trust-owned property. Okay, we can avoid probate that way as well. And I think the next slide is my property passing slide. Okay. So here's what we'll do. We start at the very top for your estate. Things that have your name on the account or the name on the asset. If it's a probate asset, we're going to go to court. Okay. Which you can see what a probate asset is here. If it's a non-probate asset, we don't have to go to probate court. Okay. So the goal is to try to make all of your assets non-probate assets. Okay. The reason why is because it's court, again, for probably the 12th time I'm saying this. Probate court's not the most fun you're ever going to have or your kids are going to have in their life. It's a headache. Okay. What happens if you die without a will? What if you do nothing? Okay. The laws in the state that you reside will determine where your money is going to go. You don't get to decide where your money is going to go. The laws in the state that you reside will determine where your money is going to go. Okay? So if you do nothing and you don't put any beneficiary designations on any of the accounts, or you don't make a trust and you die, then the state and where we're at in the state of Michigan, the intestacy laws in the state of Michigan will determine where your assets are going to go. Okay, so we're done talking about what happens when you die. Now we're going to talk about what happens when you're alive. Okay, and I just have a few slides on this. It's called a power of attorney. As I mentioned earlier in this presentation, the power of attorney is the most important document you can make. This document basically makes this, you can designate someone to make healthcare and financial decisions for you if you cannot make them for yourself, which is really, really, really important, because I'm sure everybody on this presentation in this meeting today has had somebody in the hospital at some point in their life that probably couldn't make decisions for themselves, where they needed somebody else to make those healthcare decisions or financial decisions like pay a bill or something along those lines for them. This is why powers of attorney are so important. Factors to consider. When will it be effective? Healthcare powers of attorney are always effective when you're not able to make your own healthcare decisions. Very simple. Financial powers of attorney, you can make them active when you're not able to make your own financial decisions, or when even if you're able to make your own financial decisions, either or. You can determine what powers, what rights, what authorizations you're giving to your agent to make for you. You can limit it. You can give them all the power in the world. Okay. Healthcare directive. Okay. This is a very, very important topic, because if you're in the hospital and you're not doing so well, okay, and you never had this conversation with your family of, hey, if I'm in really bad shape, if I'm in a very bad health condition, here's what I want you to do if I can't make decisions for myself. Okay? Here's what I want you to do. I want you to pull the plug. Okay? Or I want you to keep me on a ventilator as long as you can. Okay? This is the document you can make to tell your family in writing of what to do if you're in that situation. Because if you're in that situation, you probably won't be able to tell your family that. Okay? Healthcare directives. Okay? Healthcare agents, giving your agent the authority to make healthcare decisions. The difference between that and your end of life instructions is what instructions you're giving them if you're at your end of your life. Okay? That is all I got to talk to you guys about today. I kept it under an hour. That was awesome. So I'll go ahead and have you guys ask any question that you guys want at this point.
Yeah, well, thank you so much first, Amir. Yes, we have a few questions. Safsan Barnoura asks, can you implement the last will and testament without going to court if it was agreed on among the beneficiaries?
Can you implement the last will and testament without going to court if it was agreed upon the benefit? Okay, So you're talking about if your mom and dad die, and there's a last will and testament, and you don't like what it says, so you want to change it.
No. Whatever
Oh,
is in the will and the last testament that
yeah.
was agreed on and signed on, if the kids, agreed on, I mean, like they know about it, do they still have to go to court to implement it, or they can like just, process
Yeah,
it among each other?
that's a very good question. So the reason why we have to go to probate court is because if your mom and dad own a bank account, let's say,
Mm-hmm.
and it only has their name on it, okay? If you go to any bank, and Nahala's got my back on this one, all right? If you go to any bank and you say, hey, all of our kids are here, we're the kids, here's the last will and testament, give us the money. The bank will say no, because you have to be able to sign, have the authority to withdraw the money out of the bank account. Getting the authority to act for your parents is called probate. Without the authority, you cannot access the money out, receive the money, or withdraw the money out of the account. So just like you have a last will and testament, nobody has the authority to take the money out without going to probate.
Yeah, that's true.
Okay. All right. So, Suzanne, you said, is a trustee the same as an executor? Joanna, thank you so much for answering that. Correct. I like the answer that you know the executor is for a will, or in Michigan, we call it the personal representative. Okay. And the trustee is for a trust. Executor or personal representatives is a court appointed position. The court has to appoint you as the executor. The trustee, the trusts appoint you as a trustee. So you don't have to go to probate court in order to be a trustee. But in order to be an executor, we have to go to probate court, and the court has to designate you as that power, or I'm sorry, the executor or the personal representative.
You referred to a trustee as an organization. So does it have to actually be like a law firm, or can I appoint somebody like my brother as a trustee?
Oh, you absolutely can. You absolutely can. So
Okay.
typically we have family members be trustees. Okay. In some odd instances where there is no family, let's say, then sometimes they'll appoint a um, like a trust company. Okay. Here in Michigan, we have like Huntington Bank and Chase, and there's a couple other trust companies that get appointed as trustees if there's no other family. But most of the time, it's family, right? Attorneys, I don't at least ever become trustees for anyone. The only time I become a trustee is when the trustee's not doing the right thing, and the court says, "Hey, trustee, you're out. We're gonna appoint an attorney to do the right thing." So I know it sounds a little odd that attorneys are appointed to do the right thing. So, but yeah, good question though. Very good question. Um, another question is, once an asset is released to the beneficiary from the trust, is it still protected? The answer is no. So what I like to have happen in trust administration is, if the beneficiary doesn't need the asset, okay, it can be held in trust for the benefit of them still. Okay. Also, want to say a caveat too. If the trustee and the beneficiary is the same person, the asset is also not protected. Okay. So what we typically do in our office is, if the trustee and the beneficiary are the same people, and the beneficiary is going to get sued or divorced or whatever it may be, I make the trustee resign and let the next person who we appoint be the trustee, so that that beneficiary can be protected. Okay. Um, so yeah, good question. Very good question. How can you establish a beneficiary designated asset? Okay, good question, Mike. So just like Nahal said, you can go to your bank, go to see a banker at the bank, and essentially you can just say, hey, I want my son to receive these assets. Okay. Now, if the kids are minors, you probably don't want to do that, because we're going to have to go to court anyways to do a conservatorship, which is a whole different presentation, a whole different topic. So I wouldn't recommend putting minor children as beneficiaries of anything. It's just a big headache. Okay. And one of the questions, I like this tax question, is estate tax free. So in the federal estate tax limit right now is you can let your beneficiaries receive up to $15 million without having your inheritance be taxed. Okay. Not many people I know have more than $15 million. And by the way, that's a person. So if it's a husband and wife, he can give away 15 million and she can give away 15 million. I don't know if I know anybody worth more than $30 million in my life at this point. So that is one thing I want to make sure that I provide to you guys, that nobody really has estate tax problems. Okay, none that I know, at least. Okay. One thing that you guys do want to know, though, is what's called a step up in basis. Okay. That allows for, let's say you own a house, okay, and you give your house to, you leave it in trust for the benefit of your kids. Okay. Well, that's the smartest way of doing it, of giving it to your kids, is letting them inherit it. And here's why. Essentially, if you buy your house for $100,000, okay, and you sell your house for $250,000, what happens? There's capital gains, right? Okay. Now, what if you let your kids inherit your house? You say, let's say you buy it for $100,000, but the moment you pass away and they inherit it, it's worth $250,000. Okay. What that does is your kids receive the house like they paid $250,000 for the house. So if they take that house by an inheritance that's worth $250,000 and they sell it right away for $250,000, it's like they bought it for $250,000 and they sold it for $250,000, which means how much capital gains are we dealing with? Zero. So that's why it's best to let your children inherit the house instead of going to a title agency and putting their name on the deed. Because once you put their name on the deed, they receive it with the same basis like they paid $100,000 for it, just like you did.
Do you mean
Okay.
that they won't be taxed on the capital gain at 250 because they haven't actually received the money? Like
if they inherit it, they won't be taxed on the capital gain.
Okay.
But if they receive it while you're alive, then they're going to have a capital gain problem. Yes. Okay. Are you going to touch on the different types of trust? I'm not going to really touch on the different types of trust because the most common one today is the revocable trust, the revocable living trust, which is probably the most popular one. When we talk about irrevocable trust, when we talk about asset protection trust, those are more specialty trusts for specialty situations. Okay. So those are for people that have sometimes so much money that they are never going to spend it. They're scared that they might get sued one day. Okay. And they want to get it out of their name so that if they do get sued, it's not in their name anymore. So any creditors coming after them individually won't be able to touch it.
Can I add one more thing, Amir, on that?
Absolutely.
Yeah, so revocable trust, when somebody passed away, so there are trustee, successor trustee, you can go and do changes to the trust and successor trust. So when somebody passed away, you can add people. Irrevocable trust, and people do it when they don't want to do any changes to the trust. When somebody passed away, these people stick to it. So whatever who is the beneficiary, the successor trustee, they stay. You can't do any amendment or any changes. And sometimes people do it for a reason because they don't want to give any kids, other kids, or anything about that. So these are like the most like important things about these two.
Yeah, good point. Very, very good point. We don't do a lot of irrevocable trust because people want the
Yeah.
ability to be able to amend it or revoke it or change it. Okay. So again, the irrevocable trust, most of the time, it's people that have so much assets, or like, let's say, property that they want to keep in the family. Okay. Um, so yeah, that's how we, but again, we're not going to go through each type of trust. I left my phone number on my presentation, and I'll be more than happy to give it to anybody that's asking for it. But if you guys have questions about this, feel free to contact me. Amir, you a nice name, by the way, Amir. You asked a question about owning a business, which I know a lot of us on this call right now own a business. So that's a very, 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 very good um, topic. We just need to let me touch on real quick. If you own a business, okay, how do we get a business into a trust? Okay, there is a form with what we call assignments. We do plenty of assignments for business owners. So if you have an LLC, you have membership shares. If you have a corporation, you have stocks. Okay, what we do in our office is we assign those shares of the LLC or assign the stocks of the corporation into the trust automatically upon your passing. So the business will stay in your name, just like a beneficiary designation. But we make those documents internally with the corporate documents or the company documents, the LLC. We call them buy-sell agreements in our office. Okay. So if you do own a business, it's very, very important to talk about estate planning because a lot of times your beneficiaries don't know how to run your business. And that's what I was alluding to earlier when I was talking about the presentation I made a few months ago. If you passed away, will your business survive? And right now, is your business profitable? Okay. Will it tank if it gets to the next level, gets to your husband or your wife or your kids? Do they know how to run your business? Yes or no? You worked very hard building your business, making it prestigious and profitable. Okay. And with no proper estate planning, it could be detrimental to your business. Things that we talk about during business estate planning too is who would run it? What would be their instructions? Would you just want them to sell all the equipment or sell all the inventory or whatever it may be and just call it a day? Or would you want somebody to run it? Maybe you have a manager in your business that you can say, hey, I want this person to run it. I want to give them a certain salary or a certain compensation, but I want the rest of the proceeds to go to my family so they can live nice and easy. Okay. So that's very, very important, especially when you own a business. If all beneficiaries died, what should happen to the assets? Oh man, we have a pessimist in the group today. What happens if everybody dies? Okay, that's we have this conversation. I like this answer. In all of the trusts we do, if everybody dies, we make sure that all your assets go to Amir AbuAita. That's it. Like that's the answer. Sorry, it's not much. No, I'm just joking. I'm just joking.
Beautiful.
Essentially, you get to decide. Now, there's going to be at some point you're going to get blue in the face because you're not going to be able to figure out who else that you want to have. Okay, I wanted to go to my spouse, then my kids, and if not my kids, my grandkids, and then if not my kids, grandkids, then my brothers and sisters, or mom and dad, or whatever it may be. You're going to be blue in the face if we keep creating hypotheticals like that. But eventually, we start being realistic about it, right? Is all your family going to die? Probably not at one time, at least.
Yes.
Okay. So, but we would default to up to Michigan and test state law in the state of Michigan. Say, all right, well, if everyone dies, let's see what the state law says on what to do in case everybody passes away. Okay. And Amir B, yes, I do this kind of work. This is why I'm presenting on it today.
Sorry, yeah, my microphone just started working. I didn't have it set up.
That's nice to hear your voice, Amir.
Me too, bro. Yeah, we should talk.
Perfect. You have my phone number.
Yeah.
All right.
And,
Any other
and we have
questions?
Suzanne raising her hand. Would you
Oh,
like
yeah, Suzanne, I'm sorry.
Oh,
That's all right. Okay, so you said you don't recommend putting things. I have two little boys. They're minors. So you said you don't recommend putting anything in the name of a minor. So can I just assume, just to simplify it, because I know it's complicated, but just the simplification of this concept is that I would give everything to a trustee, and then specifying that when my children turn 18 or 22 or 57, whatever it is that I decide, then the trustee will pass that along to my children. And that's the end of that story, right? In the
Perfect.
meantime, do I also put the trustee's name like on my bank accounts and things like that?
Yeah, so you don't put the trustee's name as a person. You
No,
put
but
the
like the
trustee's name
beneficiary,
as a
like,
trustee of the trust. Okay.
okay.
So they would be able to only be able to access those funds because they're the trustee. The trust would actually be the account would be owned by the trust, but they have the authority to access the assets in the trust. Okay. But yeah, you understand I think you understand the concept of it. But yeah, that's how you would basically place beneficiaries on the trust as the beneficiary on those accounts.
I think the confusing part to me is you're talking about the trust as if it's its own entity, and
It is.
I'm figure out like what that entity is. Do you know what I mean?
It's okay. So you have a social security number, right? The trust, when you establish a trust, the trust has its own social security number too. And it's that social security number of the trust is your social security number while you're alive. So
Okay.
I know it sounds funny, but you got to trust me here, okay? When you pass away, the trust will have its own social security number, or it's called a tax ID number, but it won't be your social security anymore. We would have to go on the IRS website to make its new tax ID number. So it is essentially an it's an individual. It's a person. It can't get sued. It can't die. It can't get divorced. It can't steal money. Okay. It's literally the most trustworthy thing you can create because you can control it. The
And where
only
am
person,
I?
what's
Like I
that?
have to go to a law firm and have a trustee, a trust established, right?
Yes.
And then it becomes its own little human being
Yes.
later after I
Yes.
die.
And it's
Okay.
called the Suzanne Yatim Trust, let's say. Okay.
Yeah.
And that's the name of it. And then while you're alive, the social security number would be your social security number.
Sure.
Okay?
It's attached
So
to
if
me.
you go to Nahal at the bank and say, all right, I want to place my trust as the beneficiary on my bank account. Okay. Because in your trust document, you said, hey, I want my two boys to receive it at 22. So you already made the instructions. But now you take your trust and you say, hey, Nahal, I need the trust to be the beneficiary. And then when they're making the beneficiary designations, they might ask you, well, what's the social security number for the trust? And then you say, well, you know what? You can use my social security number because I'm the owner of the trust. I'm the main beneficiary of the trust while I'm alive. When I die, then it becomes the two boys who are the beneficiaries.
Got it. Okay. Thank
Okay.
you. That's really helpful.
Perfect. Nahal, did you have a question?
I want to add something to them. As you mentioned earlier, Amir, the trust is very expensive if you are going to create a trust to make the papers.
It's
Years
not super
ago,
expensive.
yeah, years ago, the bank didn't allow it without having trust paper. Now it have been changed. So some banks, if you are interested to change your account to a trust, you can go to a bank and you have to sign a certificate of a trust. It work for that specific bank. It doesn't work for any other bank. So each bank have their own form, and you can put your bank on a trust and choose who your trustees without paying no money. So that's just for the people who want to do it without paying any fees.
That's good. Thank you, Nihal.
Yeah.
Mhm.
Yeah. And let me just comment on the cost of the trust, right? I mean, here's how I feel about cost of the trust. I mean, I guess I'm being partial because I'm an estate planning attorney, but typically if you do this the right way the first time, you shouldn't ever have to do it again. Okay? The trusts don't expire. I had a trust from we were administering a trust that was created in the 1920s. The paper was so yellow and yucky and all that fun stuff, but it was still a valid trust. So So it's not like every 5 years you have to create a new one and you have to pay more money and things like that. It's usually a one and done. Okay. Can a person without citizenship be a beneficiary in the U.S.? Can you elaborate on that question?
Risala?
Yeah, hi. Like
Hi.
if I want one of my brothers or sisters and they are not US citizen, can be a beneficiary for me?
Absolutely. Absolutely. No problem. No problem.
Do
I
they
thought
have
you
to
guys
live
were
in
going
the
to ask me
States?
a hard question like, how do we estate plan for property owned in Beit Sahur, right? Please, nobody ask me that question, okay?
I thought about it.
What if, so Amir, did you have a question?
Yeah, so to comment on hers, her question, what if so if the person lives overseas, let's say, does that work that way too, or
Mhm.
yeah?
Yeah, absolutely. Absolutely. You can make the beneficiary whoever you want it to be. Um, uh, I'm not going to get into how crazy sometimes my clients are, but they've had some really wacky beneficiaries placed on their trust. So, um, what if your net worth changes with time? Do you have to keep making changes to the trust? No, absolutely not. Good question, because that actually makes me think about another topic is what if, I'm going to pick on Suzanne for a second because she said she has two boys. What if she has three boys? Okay. All right. What if she has kids? I'm going to pick on her because she just told me she had kids. Okay. What we would typically say in the trust is we would play out as many scenarios as we can. So we would say in Suzanne's trust, we would say, I want all my stuff to go to my children at the time of my death. Well, if we said I wanted to go to my two boys, yes, Suzanne would have to come back to me if she has another child. Okay? Good estate planning is done where you can account for those things in the future. So instead of saying, hey, I want my two boys to receive everything, I want my children to receive everything. So if there's another kid, she doesn't have to run back to Amir and say, hey, Amir, I need to pay you some more money to make a change. When the amount of net worth changes, that's the same thing. Okay. If there's a beneficiary designation, whether you have $100,000 in the account or $100 million in the account, okay. Well, if you have 100 million, we should probably talk about tax planning. But if your net worth changes significantly, those assets in the account, whether they're 100,000 or 200,000, are still going to be, the trust is still going to be the beneficiary of that account. So you don't need to update your trust just because your net worth changes. One other thing I want to say about the children thing too is sometimes people make estate plans and they don't have grandchildren yet. Okay. So we put that into account as well. So we say, hey, if your kids have kids, do you want your grandchildren to receive the kid's share if the kid passes away, God forbid? So we put that into account as well because we don't want a client to have to pay extra money to make a change in the estate plan that says, oh, Mir, I'm a grandparent now. I need to update my estate plan. The answer would be, well, no, I already put it in your trust. If you have grandchildren, if your kid dies, his share or her share would go to their kids.
And that even works as you acquire more assets over time?
Yep.
What about life insurance?
I hope you have beneficiaries on your life insurance. So instead of your, let's say, spouse or your children being beneficiaries of your life insurance, you can place a trust as a beneficiary of a life insurance as well. Good question.
Well, it's 8:35 or 9:35 your time, so I guess let's stop here. I mean, we're gonna send the PowerPoint, if you don't mind, Amir, to
Yeah.
all the emails that we have. If you don't get emails from Beit Sahur USA, please type in your email so we can add it to our mailing list so you can receive the PowerPoint. And thank you so much for attending. And I'm gonna let
Zain just
Munir
joined our group chat. Hi, Zain.
and
Here
Amu
is-
Munir would
Good
like
night.
to
Here
take
is
it from
Zain.
here.
Say hi to everyone.
Hi.
Hi.
Hi, Zen.
You are famous tonight.
He's famous. I talked a lot about you tonight. Hope you
Yeah.
Amir, on behalf of Beit Sahur USA, we would like to extend our sincere appreciation to you for hosting such an insightful and impactful webinar. Your generosity in sharing your time, expertise, and practical advice with our community is truly commendable.
Thank you. It was an honor.
Thank
The
you.
guidance you provided on protecting our assets was both empowering and invaluable, and we're really and truly deeply grateful for your continued commitment to educating and lifting our community here in the U.S. God bless you,
Thank you.
Amir.
Thank you, Amo. I really appreciate it. I
You
appreciate it. That means a lot. So,
Thank you, Amir.
All right.
thank you guys for
Thank you,
having me.
Amir.
Thank
Wonderful
you. Thank you
webinar.
so much, Amir. And thanks
We're
everybody
gonna
for
have so many
attending.
phone calls, Amir.
That sounds
Thank
good.
you,
That
Amir.
sounds good.
Thank you.
Thank you,
Thank
All
you,
right. Thank you
Amir.
guys.
Amir.
Have a good night.
Thank you.
God
Thank
bless.
you.
Good night, everyone.
Have a good night. Thanks.
Good
Good
night.
job. Thank you.
Beautiful webinar.
Hi, man.
Hi, who's there? Us. Suzanne,
Hello.
where are you?
I tried to the whole time.
Well,
Okay. Bye.
I thought I hung up. Yalla, bye.